Good morning, everybody, and welcome to our webinar on Marketing and Advertising 101, Understanding Your Legal Obligations. My name's Rebecca Wood, and I'm the Practice Group Leader of LegalVision's regulatory team, and I'm joined today by my colleague, Silje, who's also a lawyer in my team. Before we begin and get into the presentation, we've just got a few quick housekeeping items to cover. Firstly, you're going to be emailed a copy of this webinar recording, so no need to take notes. You can submit your questions for our Q&A session at the end of the webinar into the chat box at any time. And once the survey is completed, once the webinar is completed, please complete the webinar to let us know what you thought. Also, just letting you know that all attendees today are eligible for a free consultation with us to discuss how we can help you with your advertising and marketing or any of your other legal needs. All you need to do to request this free consultation is provide us with your contact details in the survey that appears at the end of the webinar. So today we're going to be discussing the following topics: how advertising is regulated in Australia, misleading and deceptive conduct, comparative claims, greenwashing, online advertising, Spam Act requirements, online reviews and influencer posts, and finally we're just going to wrap up with some key tips for compliant advertising and marketing. So as I said earlier, at the end of the webinar, we're going to be answering some of your questions, so please submit them throughout the webinar using the chat functions and we'll answer them at the end. So I'm just going to hand over to Silje, who's going to give us a bit of an introduction to the regulation of advertising and marketing in Australia.
Thanks, Rebecca. So as more of advertising is now becoming below the line, it's digital, it's online, regulations have become more and more specific to the different mediums and the different products and services. To an extent, the industry is self-regulated, as you would know. There is a body called the Australian Association of National Advertisers, which administers a really comprehensive body of self-regulatory rules and codes that advertisers and marketers need to be aware of and comply with. These rules are contained in these codes and they apply to all marketing and advertising material across any medium, with the obligation to comply being on you, the advertiser. So some products and services, it's really important to note at the top, have very specific regulations. We're not going to go into this. For example, gambling or cosmetic products, they have specific industry codes and standards. But what we're going to be focusing more on in this webinar is the Australian consumer law and how that applies generally to advertising. So now I'm going to hand over to Rebecca to talk in more detail about how advertising is regulated in Australia.
Thanks, Silje. So that's right. So all advertising and marketing, depending on the particular nature of it, has to comply with the Australian consumer law. And the main overarching requirement is to make sure that your advertising doesn't engage in any misleading or deceptive conduct in relation to, the quality, value, or grade of your goods and services, the performance or characteristics, benefits, and uses of your goods and services, the place of origin, so where it was made or assembled. So for example, if you want to make a particular claim that your product was made in Australia, there's some very specific obligations or rules about using that particular claim. Also the buyer's needs for the goods or services, testimonials in relation to those goods or services, and any guarantees, warranties, or conditions that you're imposing on the sale of the goods and services. So these requirements apply to both intentional and unintentional statements. So what that means is if, for example, you've made a particular claim and it is, I guess, you hadn't really thought it through and it accidentally could be misleading and deceptive, well, that's still going to be captured it's going to capture the eye of the ACCC and still could land you in a little bit of hot water. So it's just important to make sure that you're being really clear in your advertising. So what happens, or who's the bodies that look after or are honed in on looking for problems with advertising? Well, the ACCC is the key regulator of the consumer law, and it, together with state and territory consumer protection agencies, so for example, Fair Trading in New South Wales, are the regulators that will enforce the consumer law, investigate contraventions of the consumer law, and potentially impose some significant financial penalties depending on the nature of the issues. So what exactly is misleading and deceptive conduct? Well, in essence, there are two fundamental rules. So you can't engage in conduct that's likely to mislead or deceive, and you can't make any false or misleading claims or statements. So there's a little bit of overlap, but in essence, when you're making a claim about a particular product, you need to be really clear about what its intended use is or how it can be used. You can't be making any claims that perhaps exaggerate the use to an extent. We'll talk about puffery, but you just can't create an overall impression that what you're trying to do or the way that you're marketing your product is actually false or inaccurate. So whether that any conduct or particular claims that you're making about your product are misleading or deceptive will really depend upon the factors around the conduct. So what this means is that your advertising as a whole will be looked at. So for example, if you've made a particular claim, you would perhaps look at, well, what are the other imagery surrounding this particular claim? Have there been any other contradictory statements? Is there any disclaimers? Not that disclaimers will protect you from any or from all claims, but they could be quite important in determining whether or not the advertisement as a whole is misleading or deceptive. So let's just circle back to that term puffery. There's a legal term that we refer to as puffery. So this is used to describe wildly exaggerated particular claims about your goods and services that no one reasonably is going to take seriously or find misleading. So, you know, I'm sure all of us have seen a pub with the best steak in Australia, or a Thai restaurant that's got the best food in Sydney. Most consumers will know, you know, that that's just a bit of an exaggeration and no one's going to take it seriously. So that kind of puffery is okay, but it's a delicate balance between, I guess, making a claim that's kind of exaggerated versus something that perhaps people might take to be true. And that's the balance to get right. So if a claim can't be, I'm just moving on to misleading claims now. If a claim can't be substantiated, it can be considered misleading. I'm going to just talk about a practical example here. So earlier in this year, Samsung was ordered to pay $14 million in penalties for engaging in misleading conduct in relation to the advertisements of its mobile phones. They had a campaign advertising a new phone, which showed the ad being used in a pool and around the ocean, in the water, so creating the impression that it was a waterproof phone or water resistant. The ACCC investigated and alleged that Samsung did not test or sufficiently test to determine how exposing the phones to water could actually affect its usable life, and knew that certain phones in fresh water, for example, chlorinated, non-fresh water, so chlorinated or salt water, would actually damage the phone. They had actually denied warranty claims because when phones were damaged in the water, and so conducted an investigation. Ultimately, Samsung had to admit that it had made false and misleading claims about the water resistance of their phones because they knew that submersion of phones in that kind of water could actually corrode the charging ports. And its parent company at the time had actually been working on trying to resolve the corrosion issue. 3.1 million sales of mobile phones had happened in Australia at the time. So $14 million is a pretty significant penalty. You know, pretty silly advertising, I suppose, if they knew that phones actually couldn't be used in the water. But just a good example to show that how seriously, how serious these matters can be. Now, silence can also be misleading. So, for example, if your sales people are advertising particular products to people who might come into a shop front, this can also happen in the online context. And for example, you know that a consumer needs a product for a specific purpose, and they ask you, I want a product and I need it to do this, and you sell them a product, knowing full well that it's not going to actually fulfill the purpose for which they were actually trying to get product. The silence or the admission to clarify can also be considered misleading conduct. So that's really important to be aware of in terms of, I guess, managing your sales agents. Now, comparative advertising is really a big thing in the industry in advertising, and Silje is going to talk about comparative advertising.
Thanks, Rebecca. Yeah, so comparative advertising is when you compare your product to another competitor's product, essentially. It can be a really effective way of explaining or showing consumers how your product is more effective or better than somebody else's product. You know, side by side, there's lots of examples of how businesses have used this type of tool to advertise their product. You might compare factors such as price, quality, the range, volume, lots of things. Comparative advertising is a direct challenge to your competitors, and it's really important that before you use it, you consider a few different things. Those things are, is your comparison accurate? Are you saying accurate things about your competitor's product, or are you misconstruing their product? You need to take that into consideration. Number two, are the products or services being compared actually similar? So there's lots of examples of where brands have done a side-by-side comparison of two products, and the ACCC or courts have found that that product they're comparing to actually isn't similar enough to be putting them side by side. So something to consider. Also, will the comparison be valid for the life of your advertisement or your promotion? An example of this is a brand that claimed their batteries lasted longer than other battery brands, and essentially throughout the duration of the advertisement, the competitor batteries had improved the battery life of their own batteries, meaning the advertising was no longer relevant and it was actually misleading because it wasn't correct anymore. So you really need to consider, if you're going to do a comparative ad, that it's actually going to stand the test of time and that you're constantly updating it, checking it, making sure that it's accurate. Otherwise, you could be found to be misleading consumers. So moving on from comparative advertising to talk about greenwashing. So greenwashing is a term for when a business is making false statements promoting environmental or green credentials. And I mean, there's so many examples of this today. For example, you know, our product is 100% made from recyclable materials, or our product is sustainable, or our product is organic, and lots of different examples of that today. The ACCC has recently announced that they're cracking down on these kinds of claims. And they've announced that they're targeting, and they're doing a very targeted sweep, focusing on challenging misleading and environmental sustainability marketing claims and fake or misleading online business reviews. So as we, as consumers, are becoming more and more interested in purchasing sustainable products and more environmentally friendly products, that's becoming more of a decision maker for a consumer as to whether they're going to go with this brand or this brand. It's really important that when you make those statements, they are backed up by evidence. This is something the ACCC is taking really seriously. So it's very important that you're being honest and truthful, that that you can substantiate your claims, essentially, that you're backing them up with evidence, that you're using language that the average person can understand, so that we're not misleading consumers about the environmentally friendly nature of your product or service. So moving on now to advertising through search engines and other online ads. There's such a huge range of online advertising channels being used today. I mean, there's Google, there's social media, promoted posts, there's pop-up ads, there's banner ads, there's so much different mediums of online ads that we see today. Technology is changing, but the requirements of the Australian consumer law remain applicable. For example, all businesses involved in placing advertisements on search engines have to take care that they're not misleading or deceiving consumers, even in those small amount of words that you get to use in your online ads. There's an example there on the slide. Another example is, just to sort of spell this out for you, one thing that a lot of clients are coming to us today, they're concerned about bidding on competitors' AdWords. So an example of that is, let's say you've got Pepsi, for example. They might want to bid on Coca-Cola as an AdWord, as a keyword. They are allowed to do this as long as the keywords don't appear in the advertisement so that's visible to the person searching. Obviously, if Pepsi started using Coca-Cola in their heading and you clicked on the link thinking you were going to Coca-Cola and you ended up at Pepsi, this would constitute as misleading and deceptive conduct, and also trademark infringement for that matter. So we have to be careful that when we're using these online ads and we're bidding on competitors and we're using sponsored links, that as a consumer, you're not clicking on links thinking you're going somewhere else, you're going to this brand when actually you're going to a competitor's brand, for example. It's essentially boils down to, are you confusing people? Are you making them feel like they're clicking on someone's link when they're actually going somewhere else? That's what it boils down to from the perspective of the ACCC. So now I want to throw back to Rebecca. She's going to talk in more detail about the Spam Act.
Yeah, great. Thanks, Silje. Look, it's very important to make sure that you're doing all of the right things in terms of your advertising, so avoiding misleading and deceptive conduct. And it's great to, to be mindful of, I guess, the more obvious claims. Important to not fall down in terms of your advertising when it comes to your, direct electronic marketing. So it's important to understand the specific requirements of ensuring that you're complying with the Spam Act. So when you're, sending catalogs in the mail to a particular person, or using targeted online advertising, using personal information that you might have collected through marketing exercises, it's important to ensure that your direct messaging, so your emails, SMSs, MMSs, all comply with the Spam Act. And it boils down to a few key requirements. You have to ensure that you have consent from the recipient to send such commercial electronic messages. The sender is identified, so your business is clearly identified as the sender, so there can be, I guess, no confusion as to where this particular communication is coming from. And there needs to be a functional unsubscribe facility in the message. So in essence, the recipient has to be able to communicate with you that they want to opt out of these future communications. And as soon as they opt out, you need to make sure that they're removed from your direct marketing mailing lists so they don't get any further communications. Luckily, we've got a very handy document that summarises your key legal obligations into the Spam Act that's going to be available from download. It's also important to ensure that you're collecting personal information in accordance with the Privacy Act. So every business should have a privacy policy that ensures compliance and lets clients know how they'll treat their personal information. Again, this is a business need of yours. Arrange a consultation and we can discuss a privacy policy with you. Now, finally, I'm just going to hand back over to Silje to talk about online reviews and testimonials.
Thanks, Rebecca. So online reviews and testimonials, this is actually another key priority area for the ACCC in terms of enforcement for 2023. Reviews and testimonials, as we know, they're very popular tools that businesses use to help promote their brand in the public, to show they have a good reputation with customers and consumers. And it's a really useful way, I know personally, before ever I go to a restaurant or use a service, I'm looking up their online reviews and seeing what other people think about them. So we know that we rely on them and that they're so useful in terms of making a decision about whether to go with one business or another business. So knowing how much we rely on them as a consumer, obviously the ACCC are concerned when businesses are misusing these sorts of avenues, and the ways that it can be misused that the ACCC are concerned about are when there's fake reviews online. So when a competitor business, and we've certainly dealt with clients who've had these issues, has anonymously posted a fake review and to try and damage their competitor, and it's obviously false, or when you're using different tactics to influence a consumer to do a false positive review even, that is also misleading and giving a misleading impression of your business. Another example is we see businesses asking if this is okay, when you selectively try and edit or remove reviews from platforms that are negative for, obviously commercial reasons. However, that is seen to be misleading. If that's a true and accurate review, it's not false, then it can be seen as misleading and deceptive conduct if you start removing those sorts of things and removing comments that say accurate things to try and give a different impression of your business and mold the impression that isn't a true impression. So this is really important to keep in mind when you are thinking about your reviews and the way that you use review platforms. Good point to note is that Rebecca and I actually presented a webinar on dealing with negative online reviews. So if this is something that is particularly of interest to you, if you'd like to learn more, there's a whole webinar available on YouTube just on this topic. So we can go into more depth on this. Moving on to influencer posts. So as we rely more and more on social media, influencers are definitely dominating the marketing and advertising. They are becoming more and more reviewed and regulated. The AANA have a code. AIMCO is a specific industry body that has their own code just to deal with influencer marketing. The number one thing with influencers is that it's really important that they disclose clearly that a product that they're featuring on their feed, on their social media, is actually an ad or it's sponsored when there's a relationship with an influencer. So obviously if an influencer just goes to the shop, buys a product and posts it on their Instagram without any relationship with the brand, then they won't need to specifically say this is an ad, obviously, because they're just saying, I love this product. However, when there is a relationship, so let's say a brand's given the influencer a product for free or told them, paid them to do it, there's some sort of relationship there. It doesn't even just giving the product in kind, value in kind, would be considered a relationship. So that's really important to know. The influencer needs to be told to disclose that their post is sponsored or it's an ad. And there's different ways depending on the social media platform. You can do that. Obviously with Instagram, you can have the sponsored post banner. An example of where this was sort of in the media and misused was if you've watched The Bachelor, Anna Heinrich was the winner 1 year. She's considered an influencer. She had made a post on her Instagram where she was posing in a green dress from a brand called Runaway the Label. And the caption was, turning my apartment into a runway, then back to my PJs I go, wearing Runaway the Label, and she tagged the brand. She didn't disclose that it was an ad in any way. complaints were received by the Ad Standards Board, and they were upheld. So the brand was instructed to ask her to remove the post, basically. It just lacked any transparency, and it was clear that either the dress was gifted or she was paid to do the post. So this is definitely something that's coming up more and more. Really important that there is more open disclosure to the public and to consumers. Now I'd like to throw back to Rebecca. She's going to talk about risk for non-compliance and then summarize some key tips for compliant advertising and marketing.
Great, thanks, Celia. So if you've engaged in misleading or deceptive conduct, the consequences could be enforcement action by one of the regulators, court action, and the outcome of that enforcement action could include criminal or civil financial penalties, infringement notice penalties, some disqualification orders, injunctions, so court orders preventing the ongoing of a particular advertising campaign, or corrective advertising orders. So basically, a company would have to, get in touch with their consumers and acknowledge that they've made a false and misleading claim in their advertising. All of these things are not great for businesses. Investigations and dealing with regulators is a diversion from your core business. So that's why it's always important to, I guess, make sure that you're, understanding your risk profile, and making sure that you're doing all you can to avoid getting into trouble with the regulators. Now, apart from regulators, consumers can make complaints. Now, it may be that they complain, but they could also make financial claims. So it may be that they make a claim that they've been misled by a particular advertising claim, and as a result that they've suffered financial damages, and so be seeking compensation. Again, not great for businesses. So, what should we do? Some key tips for compliant advertising and marketing. Make sure that the information about your products and services are up to date and correct and accurate. If you're making particular claims, make sure that you can back them up with any facts or evidence and be prepared to prove them. So, for example, data is always the best way that you can substantiate a claim. Keep consumers updated if things change. So, for example, if you've advertised a particular time frame in your advertising and things change, make sure that you're keeping your consumers up to date. Finally, get advice. Advertising can be quite risky, particularly if you're engaging in comparative claims or operating in a highly regulated industry. So get the right legal advice first. We do quite a lot of advice for big companies and small companies, or companies of all sizes, on their advertising. And I guess making sure that we're helping and guiding them from avoiding misleading and deceptive claims. Now, look, that concludes the formal part of our webinar. So I'm just going to hand back over to Celia just to wrap up a couple of matters.
Yeah, thanks, Rebecca. As Rebecca already mentioned in the webinar earlier, that you can download our How to Comply with the Spam Act fact sheet in your webinar panel. So I highly recommend doing that. We also have an upcoming event that might be of interest to you, how to set your business up for success in 2023. A lawyer's perspective definitely would be interesting, I think, to a lot of businesses. You can register at legalvision.com.au/events. We're going to go into answering your questions shortly. We'll give you some time to submit them, and while you do that, we'll just take a minute to talk you through our membership. So LegalVision's membership is a cost-effective alternative to expensive hourly rates that you usually experience with other law firms. You pay an affordable monthly fee and you receive cost certainty and essentially all-inclusive legal services, including unlimited document review, drafting, amending, reviewing business contracts, commercial leases, It includes unlimited advice consultations with our team of 100+ specialist lawyers, including business structuring, employment, disputes, and more, and unlimited trademark registration. So as a LegalVision member, you don't have to worry about the hourly rates. You don't need to worry about the cost of your lawyers. Think of it as having like your own in-house counsel, essentially. We take care of all the business as usual legal work, so you can just focus on running your business. And if you are an in-house counsel, our membership is a really cost-effective solution for outsourcing your additional legal work. So we'd love to talk to you more about this. If you're interested, you can actually request a free consultation when the survey appears at the end of this webinar. And now we're going to get into answering some of your questions. So thanks so much for those who have submitted them.
Great.
I'll throw to you, Rebecca. You've got the first one.
Thanks. Look, so the first question is, can you cover the requirements of claim substantiation and attribution? So for example, say 50% of time, etc. So look, as we were saying earlier, the best way that you can substantiate a particular claim is having the data. So if you're, for example, making a claim that by using a product, you're going to save 50% of your time, what you'd need is, I guess, you'd be needing to do
research.
that comparative exercise, do your research, collate the data, and so that if anyone ever challenges you, you can say, well, look, this is all the work that we did. So making sure that you've just got a factual basis behind you is the key to making sure that you can substantiate a claim. The next question that we've got is, can I make a claim on the medicinal property of an extra virgin olive oil? This is an interesting question because very specific. Look, making medicinal claims about particular products is going to catch the eye of the Therapeutic Goods Administration, so TGA. So unless you've had your product registered with the TGA as being a medicinal product, you're not going to be able to make any claims about the health or the medicinal benefits of your your extra virgin olive oil. Look, it sounds like a specific question, something that we can give you some advice on, and we do deal with the TGA quite regularly. So happy to give you a hand if you want to arrange a consultation. As a company, what can you do when you encounter unfair competition? I'm just assuming that this means, well, what if perhaps a company has made a comparative claim against your company? So maybe, Silje, I'll just throw back to you to talk about perhaps what the company should do in this instance.
Yeah, I think it's difficult to answer this without knowing exactly what you mean by unfair. So I think it's a good one to book a consultation, or through our membership we often answer these sorts of questions in our legal advice consultations. So if we think it's an unfair comparison, for example, we need to break down, why is it unfair? Is it because it's not accurate? Is it because they're not actually accurately describing your product? Is that why it's unfair? If that's the case, then you could make a claim against that competing business that they are engaging in misleading and deceptive conduct, and essentially ask them to cease and desist this unfair conduct, or otherwise you will take it further. You might, legal action, depending on how much damage it's doing to your business. You'd weigh up the sort of pros and cons of pursuing it if they weren't going to comply with the cease and desist request.
And that action might be an injunction. I mean, and then the other thing that you can do is take your complaint directly to the ACCC for investigation as well. But I guess keeping in mind that, probably the fastest outcome would be if you took action yourself, because the regulator may take some time to investigate. Could you set out some specific guidelines for affiliate marketing? When setting up an affiliate marketing program, what do I need to consider and what are my responsibilities? What I'm going to do is just talk generally about some things to consider when you're setting up a referral or affiliate program. So I guess the key thing that we advise our client is to ensure that you're not crossing a line into engaging in illegal referral selling, which again is another thing that's regulated by the Australian consumer law. So referral selling is essentially where you persuade a customer to acquire goods or services when you've made a promise that if they buy it or if they sign up, then they'll receive a commission. If they start referring their friends, but it's essentially they're never guaranteed to actually get that commission. So what we recommend is if you're introducing an affiliate program, to make sure that you're being upfront about what's the program involves, avoid encouraging or inducing people to sign up to that platform or program for the purposes of them becoming a referral partner and then earning commissions. So that's where you could be in some danger territory. And it's always really important to make sure that any commissions or benefits that your affiliates are going to get are disclosed, and there's specific obligations in relation to disclosure under Fair Trading Act, consumer law. And look, there are certainly some various industry specific obligations in terms of affiliate programs. So again, if you need some specific advice, book in that legal consultation and we'll see if we can give you a hand. Okay, what else we got? Are descriptive stories talking about personal experiences and motivations behind starting a business on anecdotal evidence considered high risk? Silje, do you have any thoughts on this one?
Yeah, thanks. It's a good question. So I wouldn't consider it high risk. Generally, if you're talking about your personal experience and motivation starting your own business, that's great content, and definitely wouldn't consider that high risk unless you were making claims about. I think the more high risk things, like claims, are when you sort of are guaranteeing a success or guaranteeing a time frame or guaranteeing those are the sorts of claims where we often review and interrogate a bit more, where we're Rebecca would agree, we'd ask questions like, can you guarantee that? Can you actually guarantee that? Or does that happen all the time or only sometimes? You need to be able to substantiate claims. When you're talking about personal experience and motivation, I wouldn't consider that a high risk. But obviously, it's case by case, depends on what you say. That's another example of something we could absolutely look at in more detail and give you a more specific response.
Yeah. And I think that's the thing with advertising. I mean, there's obviously some very general rules, but I guess it comes down to the context. So it just depends, I guess, what you're trying to achieve in this particular post, and I guess what you're saying versus what you're trying to get in terms of business wise. So, but look, happy to have a consultation and see if we can give you some advice on this topic. Are we able to take action against a competitor who uses our brand to advertise an alternative product? Well, look, we've kind of covered this already. Absolutely, you can take action. Again, it would depend on whether or not that competitor is engaging in lawful comparative advertising or not. So it really, depends on the particular claims that are being made. But look, certainly you can take action, and that would be court action and an injunction, but probably starting with a cease and desist letter.
Yeah, and only if it was used, if it wasn't an accurate comparison, if it was considered misleading the way that they were using your brand to advertise that alternative product. It's actually not illegal or against, for example, if your brand, if you're mentioning if you're talking about your logo, for example, it's you're allowed to use someone's logo in the context of comparative advertising. So it's not unlawful to, say like to be publicizing your logo. It is unlawful to use your brand and then make misleading statements about it. So if that happens, that's when you can take legal action.
Agreed.
Some more questions?
Yeah, look, there's a question here about sustainability. Is there a counsel for sustainability who we can consult with? Look, I guess this is in relation to making, claims about environmental benefits of your products or services, or whether or not, your business is engaged in a sustainable practice. Look, I'm not aware of any, I guess, particular council or body. I know that there may be some kind of, I guess, different industry bodies that might give some advice. And I guess it really, again, just depends on the nature of the particular claims that you're making about your business, in terms of, I guess, whether it's sustainable or not, or if there's particular environmentally friendly claims that you're making about your services. So look, again, I think it's a matter of, I think it would be certainly great to do a little bit of research and to see if you can get some guidance. But it just comes down to the particular claims that you're making.
Exactly. And like it comes down to the ordinary meaning of the word sustainable. What does the average consumer assume that means in the context of how you're using it, and whether or not that would be an accurate claim to make. You need to, and this is something we review all the time. We would, often get clients who say, I'm making this claim about my product, and this is the evidence that I'm using to suggest that it's sustainable. Would you agree? Would you say this is a risky statement to make? And we often give advice to clients about whether there's a risk there to suggest that their product's sustainable. We also really focus on giving commercial advice. I think Rebecca and I really focused on that. So how can we give you, help you make changes, slight changes even to wording and advertising to make it less risky? And sometimes it just needs 1 or 2 word changes, and you've made the advertising way less risky than initially, and it still retains the aim that you were going for when you originally came up with the copy for the advertising. So yeah, there's definitely ways that we can help shape advertising and the use of words like sustainable to help make that a less risky exercise.
And I think one of the key things that we always talk to our clients about is, I guess, making or avoiding making absolute claims. So for example, just to say, like, I'm just trying to think of an example, like this is the, you're going to get the maximum benefit that you can get if you sign up with us, or we're going to help you achieve your maximum weight loss or something like that. It's more like if you can, temper some of the claims by saying, look, we can help you work towards your goals, is a better way of saying, like, we're guaranteeing you a particular outcome.
Exactly.
Unfortunately, we're running out of time. Thank you for the great questions. We have to wrap up. But look, thank you for listening along.
Yes, and don't forget to request your free consultation when the survey appears at the end of this webinar.
Great.
Thanks so much for joining us.
Thank you. Goodbye.